to me, perhaps the prior matter. I think this is a renewal action. And when he did, he was like, oh, hey, Judge Krause, this is your case. So here I am. But I have had an opportunity to review the file and to review the pleadings. And so I am prepared to hear the summary judgment motion that y'all had pending. And who represents Mr. Davalos? Is that correct?
Yes, Your Honor.
Who do you represent, sir?
The defendants, Your Honor, Mr. Porras and Goldman Trucking.
Okay. And Mr. Eno, you represent the plaintiff then, Ms. Farmer?
Yes, Your Honor.
Okay. So you're free. You are free to go ahead. I have I mentioned I'm generally aware that this is a a renewal action, that this involved an auto accident, I think with a trucking company, and that Mr. Porras is the driver, Goldman Trucking is the his employer, and they're both not local. Is that right, Mr. Davalos?
That's correct, Your Honor.
Okay.
Yeah, but before we can continue, Your Honor, if I may ask,
yes.
I would like to ask the permission of the court to stay this summary judgment action pending a criminal investigation on this case, in the sense that this was a hit and run accident. And I just got wind of notice of a pending probable cause hearing to that effect, which would affect the totality of the issues dealing with statute of limitation here. Like you said, like defendant's counsel already said, the accused, the defendants here are out-of-state residents, and it was a hit and run, if I may put it that way. So we need to at least, she needs to be given an opportunity to adjudicate that issue, because she was seriously injured. She was abandoned the road. She had to stay in the hospital for 3 days. And this summary judgment is based on technicalities. The one issue that has not been truly addressed is the criminality of this case, which may affect the statute of limitation. So I would like to ask an oral, just make an oral motion to see if we can have stay this summary judgment hearing for now until that hit and run is determined.
Okay, I'm gonna let Mr. Davalos respond. But I will just point out that I certainly am aware of that issue, but I'll note that this incident occurred almost 4 years ago. And that if there was, and it had been filed once. And so to the extent that it's been properly filed once timely, apparently, and to the extent it's been properly renewed now, the statute of limitations is not an issue. And this happened 4 years ago. And so to the extent there was going to be any investigation that might be necessary or helpful to the parties in understanding what happened and understanding the potential liability of the defendants, it coulda, shoulda, woulda happened by now. And the fact that there might be some further investigation is not persuasive to me that the case needs to be stayed in its entirety. Mr. Davalos, did you want to respond to Mr. Eno's request for a continuance or a stay?
Yes, Your Honor. I mean, we would oppose a stay. First, this is the first we're hearing from plaintiff's counsel about wanting a stay of this. This matter had been set for a hearing on motion for summary judgment already. So counsel had opportunity to bring this up to request a stay before that first hearing. And further, the summary judgment that's before the court really doesn't have a lot to do with the substantive facts of what happened during the incident. This is really a procedural summary judgment motion that really has everything to do with compliance with service, and so I just don't see how that will affect our summary judgment.
Okay. I tend to agree, Mr. Eno. I'm going to definitely go forward with the hearing to the extent that you that part of your substantive response is tied into how the possibility of a criminal investigation might change the court's substantive addressing of the issues in the summary judgment motion, you're free to continue to bring those to my attention. But staying the case or continuing this motion, given the age on this case and the age on the incident as a whole, I don't think makes sense. And so I am going to go ahead and ask Mr. Davalos to begin with his argument. And just so y'all know, you can make whatever argument you want. I'm just so Mr. Davalos knows, since your motion, I'm going to let you have the last word so you can start, and then I'll hear from Mr. Eno in response. And then I will give you a brief opportunity to rebut.
Understood, Your Honor. Thank you. So this is an action that stems from a motor vehicle collision that occurred on November 19, 2021, here in Fulton County. This is a renewal action that was brought by the plaintiff against defendants on June 13th, 2024. The statute of limitations in this case ran on November 19th, 2023. In the original action, so the original action was brought in this case back in January 30th of 2023. And that action named Enrique Porras and GM Trucking LLC. And just for clarification, the correct defendant in this case was and is GoMen Trucking LLC. GM Trucking LLC is a completely different company, completely different registered agent, just a completely separate from GoMen Trucking. Plaintiff filed an affidavit of service on Mr. Porras under the provisions of the Non-Resident Motorist Act, and that's Georgia Code 4012-2. That act was deficient, as I'll get into later in my argument. He also filed an affidavit of service on GM Trucking, which again, completely unrelated entity to GoMen Trucking, the correct party. The court then entered an order to file default on the parties, and at some point, and I was not counsel at the time, but at some point, plaintiff then must have realized that GM Trucking was not the proper party, and they filed an amended complaint now naming Enrique Porras and GoMen Trucking LLC. So GoMen Trucking LLC is the right party. However, plaintiff at no point during the pendency of that original complaint ever filed a motion requesting leave of the court to dismiss or add the parties, which is a requirement under Georgia Code 91121. At that point, Enrique Porras and GoMen Trucking file a special appearance answer in which they say, hey, you did not serve either of us correctly. Mr. Porras, you didn't serve us correctly because you didn't comply with the provisions of the Non-Resident Motorist Act, and GoMen Trucking because you have not properly added us under Georgia Code 91121. The court then dismissed plaintiff's action because plaintiff failed to show up to a pretrial conference. At the time that the dismissal happened, Mr. Porras had never been properly served under the Non-Resident Motorist Act, and GoMen Trucking had never been properly added as a party as required by Georgia Code 91121.
So, let me ask the one thing I want to clarify is, is there such an entity as GM Trucking, or was it all along that Eno was trying? Okay, so it would not be a misnomer or a name change, even though the names are close. It's just a completely independent corporate entity.
Correct, Your Honor. And GM Trucking has their own registered agent, and GM Trucking's registered agent was served in that first complaint. They're just a completely separate company that happens to have a name that sounds like GoMen Trucking.
Okay.
And so, Your Honor, since service was improper on GoMen Trucking in the original action, a renewal action after the passing of the statute of limitations cannot be brought against GoMen Trucking LLC. As I said before, under Georgia Code 91121, a party can only be added or dropped by order of the court on motion of the party. Did not happen here. I direct the court to Wright v. Safari Club, which is 322 Georgia Appellate 486, that adding a new party through an amended complaint without first obtaining leave of the court is without effect. And so Georgia's renewal statute is very clear that a renewal action can only be brought against identical defendants for substantially the same cause of action. Here, Goldman Trucking was never a proper defendant in that first complaint, and so a renewal action can't be brought against them. And the facts of this case are actually astonishingly similar to a Georgia Court of Appeals case, Valdosta Hotel Properties LLC v. White, and that's 278 Georgia Appeals 206. In that case, a plaintiff had sued a hotel company. They had originally sued the Hilton Corporation, but the proper entity to be sued was Valdosta Hotel. So the plaintiff in that case served the Hilton entity, and the Hilton entity filed a motion to dismiss saying, we're not the right hotel, you need to serve and add Valdosta Hotel Properties. The plaintiff in that case then amended their complaint without seeking leave of the court under Georgia Code 91121. They just amended their complaint to add Valdosta Hotel, and Valdosta Hotel filed a motion for summary judgment saying, we're not a proper party till you do a 91121 motion and get an order. In response to that motion for summary judgment, the plaintiff in that case, rather than seeking an order, I don't know why, they dismissed the case and filed a renewal action. And the Court of Appeals, in overturning the trial court's denial of a new summary judgment motion they filed, said, if you don't get leave of the court, that party isn't a party in the original action, and you cannot bring a renewal action against them. So really, Your Honor, the crux of the suit against Goldman Trucking is they were never properly added as a party as required by Georgia Code 91121 in the original action. And if you are not a properly added party in the original action, a renewal action just cannot be brought against you because the renewal action is crystal clear here. Identical defendants are the only people who can have a renewal action brought against them. As to Mr. Porras, apologize, Your Honor. As to Mr. Porras, Mr. Porras was named as a defendant in the original suit. However, service was never perfected on him in that suit under the provisions of the Non-Resident Motorist Act. So the Non-Resident Motorist Act is a provision that allows a plaintiff to obtain personal jurisdiction and serve a non-resident motorist, someone who doesn't live in the state, in a court here in Georgia. Now, the Non-Resident Motorist Act is in derogation of the common law, and so the provisions of the statute are strictly construed when service is attempted pursuant to it. And the Court of Appeals has been clear that the NRMA must be fully complied with before a court of the state gets personal jurisdiction over that defendant. And to that, I would cite to Fuller v. Hensby, which is 367, Georgia Appeals 624. So the Non-Resident Motorist Act, and that's 4012-2, Georgia Code 4012-2, has requirements that a plaintiff has to do, or else service is invalid. So among these requirements are that the defendant has to, or that the plaintiff has to include a return receipt of certified mail sending service on the Secretary of State and the summons and complaint and whatever other papers in the case exist to the defendant's known address. In this case, in the original action, no return receipt was ever included in any affidavit of service with the court. That alone makes any service under the NRMA, under the Non-Resident Motorist Act on Mr. Porras, invalid. It is in derogation of the common law. It has to be strictly complied with. It was not strictly complied with. Not only was no return receipt filed, there's just nothing in the record that shows that any kind of mail was sent to Mr. Porras regarding this case. Service was attempted under long-arm statute. That didn't work. There's no affidavit saying on this day I sent certified mail to Mr. Porras. There's no return receipt. There's just, as far as the record shows, Mr. Porras was never sent anything in this case. Accordingly, at the time that the case was dismissed, Mr. Porras had never been properly served under the Non-Resident Motorist Act. He had never been served personally under the long arm statute, which I don't think plaintiff even alleges that, but I just set that out there. No return receipt was filed. It's not clear from the record that a return receipt even exists or that any mailing was sent. And without complying with the provisions of the Non-Resident Motorist Act, there just is no service. And without service, without service in the original complaint, a complaint hasn't happened, or the party doesn't become a valid party, and a party cannot be renewed if they were not. A party cannot have a renewal action brought against them if they were never served in the original complaint. And for those reasons, I would ask that the court grant our motion for summary judgment. I would just touch briefly on the fact that we also moved for summary judgment on plaintiff's claims for attorney's fees. I did not see that plaintiff brought a argument against that in his response brief, but I would just move the court. It would be moot if our first part is won, but I would just move the court that plaintiff has not presented any evidence of bad faith or stubborn litigiousness and failed to especially plead the claim as required by Georgia Code 13-611. And so we'd move the court to grant our motion for summary judgment on attorney's fees as well.
Okay, thank you, sir. Anything else?
Nothing further right now, Your Honor.
Okay, Mr. Eno?
Yes, Your Honor. The renewal action on which plaintiff bases the renewal action was, as far as we're concerned, not void, but merely voidable, and therefore the basis of the renewal action. Subsequently, the renewal action is not barred by the statute of limitations. We believe that the privilege of dismissal and renewal under OCGA 92-61 does not apply to void cases, because like a defendant counsel already said, the case was voidable because merely voidable because there was an emergency and we failed to show up in court, but does not apply to allow a renewal where the action was merely voidable, like I just said. A suit is also void and incapable of renewal under OCGA 9-2-6-2-61A if there has been judicial determination that dismissal is authorized. However, unless and until trial court enters an order dismissing a valid action, it is merely voidable and not void. So the renewal statute is an action de novo, and that's what we argue. One thing, like I said before when I asked for the stay, is that this case, and I think defendant hasn't mentioned that this is a case of a hit and run, and false information, misleading information was given, and so there was a lot of confusion. Regarding defendant Porras was avoiding service, which is why plaintiff had to resort to serving him under the National Resident, under the Georgia Motorist Act. Defendant was never served personally, we agree, because again, he was avoiding service as best as he could. Now, yet failure to attach a return receipt as required by the Non-Motorist Act is act as evidence of a non-service. Under Georgia under the Georgia non-resident motorist statute, there must be at least an attempt by the plaintiff to give the defendant notice of service in the manner set forth in the case of Cheek versus Norton. Both the statute and the facts concerning the mailing of the notice must be such as to show within a reasonable probability that the defendant in fact received the notice. Affidavit of compliance with service of process on non-resident stated clearly that a copy of the process was mailed by certified mail or registered mail to defendant's last known address. And this is the address that supposedly gave. The defendant's last known address, which I think maybe now we realize after a long time, maybe fictitious, was 7504 Maskland Drive, El Paso County in Texas. That was just the address. This is the address that was given to the plaintiff after she was abandoned on the road. And numerous attempts were made at this address in an attempt to personally serve defendant Perez. On one such attempt in June 2023, we showed a package mail addressed to Rosa Porras with the same last name. So here, Your Honor, there is a reasonable probability that defendant Perez resided at that address. Further, if there had been a hearing on the issue of service in the original action, the court could potentially have made a determination that the failure to attach a receipt was an amendable clerical error. In this sense, not attaching the receipt was merely a clerical error. And there's a reasonable probability that that defendant received the notice. So,
Mr. Eno, forgive me for interrupting. Let me make sure I understood what you just said.
yeah,
That failing to attach it was a procedural defect. I think that's what I heard you say,
yes,
correct?
correct, yes.
So I guess then my question though is, if you have it, one of Mr. Davalos's arguments was that it had never been filed into the record, not just that it wasn't filed then, but that there's no indication. Has it been made part of the record at some other point or in some other way?
No, it has not, because it was not attached. In the process, my assistant who did that failed to attach it, and we did not see that receipt. But I did show.
So it's been lost or mislaid.
That's right. That's right.
Okay. Okay.
So that's why that became clear. And again, that is more of a clerical error, and it will be greatly unfair to dismiss this case just merely because of that. And like I keep saying, I think it's a hit and run accident where they're looking here to dismiss this case based on a technicality more than anything else, and not only based on the merits of the case. So we're asking that this motion for summary judgment be denied.
Okay. I'm sorry, I keep saying your name and I feel like every time I say it a different way. At least Mr. Eno's name is easy to pronounce.
Yes.
Can you tell me how to say your name, sir? You're muted, by the way.
That would help, wouldn't it? Davalos, Your Honor.
Davalos, Mr. Davalos,
It's no problem.
your rebuttal.
Yes, Your Honor. Your Honor, first I'd like to address the distinction between voidable and void. I believe plaintiff was quoting from the case of Tate v. Coastal Utilities, which is 247 Georgia Appeal 738. So Tate sets out two ways that a case can be void. So one of the ways that a case can be void is what plaintiff brought up further, is if there's been a judicial determination that dismissal is authorized. But if we read the sort of the citation from that case in full, it says the privilege of a dismissal and renewal does not apply to cases decided on their merits or to void cases. Instead, that privilege of dismissal and renewal applies only where the previous action was merely voidable. Then the case gives us two separate ways that a case can be void. If service was never perfected, then the original action is void, since the filing of complaint without perfecting service does not constitute a pending suit. Then it says, in addition, a suit is also void and incapable of renewal under the renewal statute if there's been a judicial determination that dismissal is authorized. So plaintiff's own case is very clear that if service was never perfected, it's void. It's not voidable. You don't need a judge to enter an order saying, hey, you didn't perfect service sometime during the life of the original case. if service is never perfected, that original action is void and renewal is just not proper against any of those parties against whom service hasn't been raised. I'd also just like to object to plaintiff's arguments regarding hit and run and this investigation. There's nothing in the record supporting this. These are just kind of unsubstantiated proffers by plaintiff's counsel. There's also plaintiff's counsel wants to, I guess, suggest that plaintiff is avoiding service, but also suggest that they knew an address that they could mail to. I would just direct the court again to the fact that there's just nothing in the record. There's not an affidavit. So plaintiff's counsel submitted affidavits of compliance for service of process in that original action, and nowhere in that affidavit, and I'm referring to Exhibit C attached to our motion, nowhere in that affidavit does it say I sent certified mail on XYZ date to Mr. Porras to XYZ address. There's just zero evidence in the record that any mailing was sent to Mr. Porras in that original action. And so I would just reiterate to the court, I mean, plaintiff's own case that they cited in their brief is absolutely clear. If service was never perfected, then the original action is void. There was just no proper service on Mr. Porras in that original complaint. There was a failure to comply with Georgia Code 911. Sorry, and I got to look it up every time, but Georgia Code 911-21, I believe, adding a party by motion and order of the court in that original complaint. The renewal statute is clear. You have to have defendants who are properly in a case and who are identical in that original case before you can bring a renewal action against them. That did not happen here, and for that reason, we would ask the court to grant our motion for summary judgment.
Okay. So a couple things that I want. So when this case was originally reassigned to me, and I had to go back and look and figure out, what the history of the case was and review the documents, particularly the filing history and the adding of the party, et cetera. A couple things. Obviously there's a significant interplay. This is a statutory alphabet soup in terms of all the different statutes that are relevant to this consideration. But there are a couple of things that are important to me. I think that the GoMen Trucking is an easier, it's not a close call, right? GoMen Trucking was never made a party to the original action. And that's because 9/11/21 absolutely, although a party can amend their complaint at any time prior to the entry of a pretrial order, the fact of the matter is the case law, as far back as I can remember, that says you have to read that in para materia with 9/11/21, which says that if you're going to add new parties or substantially new claims, then you have to get leave of court to file such an action. And that was not obtained here. And so GoMen Trucking was never a party to the earlier action. And so as a function of that, they could never have been, there's no way to renew a case that was never brought. And so that is an easier case for the court. I think that Mr. Porras is a closer call, but I will say that one other issue that I noted that I want. So obviously this is filed as a renewal action. The plaintiff, asserts 9261 right there in the first paragraph, which is what I've always seen done, so that everybody's clear that it's a renewal action. But 9261 also has to be read in para materia with 9/11/41, which requires that costs be paid. And I don't have, costs may have been paid, but it's not alleged in the complaint that the costs of the prior action were paid. And I don't have a record. I have the ability in our docketing system to look at the case and payments that are made into the registry associated with that case. And I don't have any record that costs were paid in that case. So and my understanding of the effect of that is that it's not a defense, it's a jurisdictional prerequisite. And so I'm concerned that it's not a proper renewal action, but even to the extent that it is a proper renewal action, I think that I think that service was deficient originally. And I also think that in the interim, once that deficient service was brought to the attention of the plaintiff in the new action, et cetera, that there were ways to remedy that, and that there's no evidence that any of that was ever undertaken, or to otherwise document the service that Mr. Eno has represented was made, right? The service using mail. There are other ways to document that might have satisfied this. I don't know if they would have, but there could have been efforts made. Just as anyway, as I said, there could have been efforts made to get to document that service was made, even if paper was lost, because that happens. We all know. I mean, the offices, things happen. But there were ways to address that, but so much time has passed now that I don't know that practically it can be done, or if that would even be sufficient. But I am ultimately, I agree with the defendants that this renewal action, assuming it is a valid renewal action because the costs were not paid for the prior action in compliance with 9/11/41. But setting that aside, Gomen was never a party, and Porras was a party to both cases, but was never properly served under the Non-Resident Motorist Act because there was not documentation of the compliance with the Non-Resident Motorist Act in the form of proof as required under that OCGA 4012-2 of compliance with the mailing requirements, et cetera. And if Mr. Porras was not properly served in the prior action, then I agree. I think the case law supports that the renewal after dismissal is not feasible here. And so I am going to grant the defendant's summary judgment motion. Mr. Davalos, can you please send a proposed order in Word format? It doesn't need to be particularly detailed, but I do want some of the case law discussion that I've just mentioned that I thought was relevant, or not case law, actually mostly statutory law, but that I've just mentioned that I thought was relevant and to my decision. And once I have that, I will get an order on file for you. Obviously, when you send it to Mr. Freehoff, who's my staff attorney, please send it in Word format because I will likely edit it. And also copy Mr. Eno on it so that if he doesn't believe that it accurately reflects the verbal ruling that I'm giving you now, he can share that with me and say, hey, Judge, I don't think this is what you actually ruled. But just ask, please do not, in emailing, neither party should consider take this as an opportunity or an invitation to re-argue your relative positions. Because I have ruled, I'm just going to subsequently enter a written order. And then, Mr. Eno, you can take whatever appellate action you choose to take on behalf of your client, and I certainly understand that. Anything that either party needs from me before we adjourn, Mr. Davalos?
Nothing further, Your Honor.
Mr. Eno?
Nothing, Your Honor.
Okay, thank you both.